Hi, this is immigration attorney Meg Moss. I have an update for my clients today. I was in court doing an individual hearing for one of my Cameroonian clients today. This was in the Sterling, Virginia court. And we've been working on this case for a very long time, and we expected to get the dreaded motion to pretermit last week, and sure enough, it did show up. So if you have not already heard, what's going on right now is DHS is trying to close by pre-terminating cases. So they want to close your case and basically deport people to Uganda if you're from Africa. So this is specific to my African clients, particularly my Cameroonian clients, because I have quite a few Cameroonian clients. What happened was we got this motion to pretermit on Thursday, and we knew it was coming. So last Friday, we filed our opposition brief. Now, the opposition brief was about 300 pages long. It included a lot of arguments as to why this should not happen. The idea is to get everything out there that you might possibly want to argue in an appeal. Okay, because an appeal cannot have new evidence in general. So you need to basically build the record, if they call it in lawyer speak. And that means we wanted to get as many things into the record as we could, knowing that we probably were going to need to appeal this case. We got the motion to pretermit on Thursday. On Friday, we filed our brief. So the brief contained the arguments, just a lot of legal writing, plus a lot of attachments in the form of articles and studies and things like that. But most importantly, it had an affidavit that was notarized from my client explaining why she feared going to Uganda also. So very detailed explanation from her, notarized and included in this packet. We also had a country conditions expert report done by a very renowned country conditions expert who covers a lot of countries in Africa, but particularly Cameroon and now Uganda. So she did a report that we included in this packet that went to the judge. So we had a long weekend. We tried to relax, just knowing, we needed to brace ourselves for today. Sure enough, when we arrived, the judge said that instead of having the merits hearing for her asylum case, we were going to talk about whether or not the ACA Uganda agreement applied to her case. The judge was really careful and very thoughtful in how he approached this. I think, was very sympathetic to my client and, did what he could to help us make sure that she had a fair moment to testify about her fear of going to Uganda. We went over all the things that were in the record. The country conditions expert report was entered into the record, and we call it proffered, where it was just accepted as testimony by the expert without her having to actually come and testify. There was a lot of back and forth. The judge asked my client about her ties to Uganda. Has she ever been there? Does she have family there? I was able to ask her some questions about her fear that got into a little more detail that was supporting what was in her affidavit in the opposition brief. Then the government attorney didn't even have any questions. He just kind of let it rest. So after that, the judge decided that he needed to take about a 20-minute break and review everything and would come back to us with a decision. So sure enough, he left for actually about 30 minutes and came back and then told us that the ACA Uganda agreement does apply to her. And ultimately, after a very, very detailed statement about how the arguments were not going to survive based on this case law that this whole thing is based on. So he very carefully and meticulously went through all that. Basically, at the end of the day, his hands were really tied, and he had to order her to be removed from the U.S. to Uganda. Now, the good news is she is able to appeal. I reserved appeal for her, and that means that she has 30 days to fight this. And because we knew that was coming, we definitely prepared everything carefully so that she will have the best possible chance to be successful in an appeal. So what comes next? Well, in her case, we filed an appeal. But we're also watching really closely to see what's going to happen with all the other cases. We are basically seeing this happen in every individual hearing that we have for people who've been here since 2019. So it really does seem to apply to everybody. I don't know that they're getting around to sending these notices in advance to everybody, but the language of the rule basically allows them to just bring it up at the individual hearing. So you don't have to get a notice in advance. They might surprise you at the individual hearing. If that happens, or even if you just need more time, the judges in general are giving people an extra 10 days or so to prepare an opposition brief. So if you haven't already done one, anticipating one, you do have a good chance of getting a continuance for about 10 days to go ahead and do that. So that's what we know. I'm hopeful that maybe a higher court is going to issue an injunction on this practice, or maybe there'll be a class action lawsuit. I mean, there's a lot of things that could happen to stop this. And if that happens, of course, that would be a great opportunity for these cases to be reopened, and then finally have the merits hearings heard. So that's what we're anticipating. But these days are crazy and anything can happen. So that's today's update. I just wanted to let you know kind of what is happening on the ground. I'm not saying this is going to happen in all cases. I'm just saying this is what we're seeing. And being prepared is probably the best possible thing that you can do if you have an individual hearing coming up. Now, remember, this does not apply to master hearings so far. It's really just for individual hearings. As always, if you have any questions or concerns about your case, please feel free to call me. I'm happy to try to explain in more detail what's going on and how it applies to your specific situation for my clients. And feel free to share this video, and hope you have a great night. Thank you.